Hello, and welcome back to Adventures in Law and Life. My name is Shannon Gunn-Emery, and I'm a lawyer in Edmonton, Alberta. Get ready, because today I am going to tell you a very scary story. If you don't actually think this is a scary story, because it's about impaired driving, generally, just wait till you end the podcast and see how you feel then. I am betting that this podcast will leave you with a few chills. So let's begin. My story starts with a very ordinary day. It was Friday, September 2nd, 2022. My husband Dale and I had been out to supper that evening with some friends of ours who were visiting from out of town. We had a lovely night. We went to the Melting Pot for fondue. Highly recommend it. It was about 9:30 at night when we said goodbye to our friends and headed back home. We don't live in Edmonton, so we knew it was going to be quite a trek back. But it's always worth it. I'm not saying where we live, but I will just give you a hint. We live in a blessed place. Dale always rolls his eyes when I say that, but it's true. But that blessed place is a 45-minute drive from Edmonton. Since Dale had had some drinks, I was driving. When Dale and I are in a car together, it's very unusual that I'm driving. That's because I apparently terrify Dale. Now, I don't take it personally. I don't think it's really me. While I admit he has good reason to fear for his life when I cook chicken, he does not have any reasonable reason to fear for his life when I'm driving. I am a good driver. Just ask me. Don't ask Dale. He's just a nervous passenger. With anybody driving. Not just me. Getting back to our story, to be clear, I had had no alcohol that night. I never do. I'm a teetotaler. By the way, did you ever think about that? What a weird word or expression that is. What does it mean? I live off tea totally? I'm not even that fond of tea. Anyway, so I had nothing to drink because I am a teetotaler. That makes me a lovely companion for almost everyone because I am always the designated driver. So we were on our way home. It was a clear night. It was a lovely drive. Dale was exhibiting far fewer symptoms of anxiety than he normally does, not gripping the sides of his seat or suddenly slamming down his foot. He was very relaxed, and so was I. That is, until I turned off the main highway and saw a whole bunch of police lights ahead. It looked to be a check stop. A check stop is where police stop drivers to see if they've been consuming alcohol. Usually in Alberta, they make you blow according to a mandatory alcohol screening demand. When they do that, it means that they don't have to have any reason to believe there's any alcohol in your system. They can make you blow if they stop you for speeding or for a seatbelt violation, or even just to check on driver sobriety and vehicle documents, like in a check stop. I wasn't worried because I'd had no alcohol to drink. I was more professionally curious. I've actually never been through a check stop before. So I was interested in seeing how this was going to play out in real life as opposed to in the police report and notes that I'm always reading. There were a couple of vehicles ahead of us, and my husband and I were just chatting as we waited to get to our point. We pulled forward. An officer began walking towards us and approached my window. I rolled my window down and greeted him politely. The officer was very friendly and courteous. We were off to a good start. But of course, as this is a horror story, you know things are going to take a turn for the worse. The police officer informed me, as if I didn't know, that this was a mandatory alcohol screening demand. And he asked me to blow. As I was preparing to blow, I was thinking in my mind about all the things that I've heard officers say on the stand. It's like blowing into chocolate milk. It's like blowing bubbles. Because if you blow too hard, you can run out of air. But if you blow too soft, you get an insufficient reading. So I thought, blow like you're blowing into chocolate milk. And why chocolate? Like, I'm sure milk, like regular milk, is the same. Anyway, so I started to blow. And as I was blowing, I was trying to maintain a steady pressure as well. But I ran out of air before the instrument registered anything. And the officer said, no, you have to blow harder. So I'm like, okay. So I took another deep breath and blew harder. But then I felt my tongue hit the hole on the front of the mouthpiece and the air stopped. I thought that was very strange. It was almost like my tongue got sucked into the mouthpiece. And the officer said, you blocked the mouthpiece with your tongue. And I said, yeah, I did. I felt it. I'm sorry. Can I please try again? He said, no problem. So take a deep breath and try again. And the same thing happened. He said, no, you blocked it again. And I was getting really nervous. I undid my seatbelt so that I could hopefully take a bigger or better breath. I wasn't sure what I was going to need to do to get a good sample. I was starting to feel flushed and starting to feel very anxious. This was becoming embarrassing and scary. The officer took the mouthpiece off. He didn't do a demo, as I noted, and he was supposed to do that according to their training manual. Actually, come to think of it, he also never asked me about my time of last drink, which of course I didn't have one, but he should have asked. The officer gave me the first mouthpiece and said we would try again. I was grateful for that. The number of tries you get is dependent on the officer's goodwill. Some officers stop at the third try, and others will still continue to give you a chance. Luckily, this officer appeared to fall into the latter category. The officer inserted a new mouthpiece into the device and said, okay, try again. I tried again, and then the breath cut, like it just stopped in the middle of what I was trying to do. And I was feeling like I was out of air, but I think it was just the pressure. I'm not really sure what it was. And he looked at me and I said, like, I'm having issues. He said, well, bite on the mouthpiece. Sometimes that helps. So I bit on the mouthpiece. I bit so hard on the mouthpiece that I heard it crack. But thankfully, it gave a good reading. The reading was 0. I exhaled shakily, which probably shows that I have enough air to do all of this. My heart by that time had been pounding. The officer said, oh, there you go. You're free to leave. Have a good night. Have a good night? I was almost trembling. Like, I was very, very nervous. It took 5 tries for me to provide a proper sample. And I was trying every single time. I was trying my best. What was scary was, at the time that I started realizing that I was having issues, I also started realizing I'm going to have no good arguments on the SafeRoads appeal. As I had made attempt after unsuccessful attempt, and it began dawning on me that I could be in real trouble here, all sorts of thoughts flowed through my mind. First, I thought, with a failure to provide samples, which is what this was becoming, I won't get a roadside appeal. A roadside appeal is where they offer you another try, but on a different device, and obviously with a different mouthpiece, just to make sure the problem isn't the instrument or the device. Weirdly, I don't know by what logic they do this, but they've decided that a failure to provide samples of breath for those situations where you just don't seem to be able to do it, you don't get a roadside appeal. You'll get it if you successfully blew and you blew over, but if you refuse outright, well, a no, why would they offer you a roadside appeal? If you said no to the first device, I assume you're going to say no to the second device. But if you're trying your best on the first one, Why would they not give you the opportunity to try on a second one? But they don't, just so you know. The other thoughts that were going through my head, okay, so I won't get a roadside appeal, and I'm going to lose. I am going to lose if I get the notice of administrative penalty and have to take this to a SafeRoads appeal, because I don't have any argument other than I'm trying my best, and that won't be good enough. That almost never works. You always need something else, like anxiety, asthma, COPD, and I had none of that. The fact that you are swearing to God that you are trying your best is not enough. And just so you know, in the SafeRoads regime, it's literally, I'm not kidding you, written into the legislation, the officer's evidence is deemed to be under oath. And then the law goes silent. The officer's evidence is deemed to be under oath. Your evidence is not. Now, you could offer evidence under oath in the form of an affidavit. Oh, how many affidavits have you drafted lately? This is supposed to be a regime that's easy for people to represent themselves. Are you all good at drafting affidavits? I sure hope you are. Because otherwise, you're going to need a lawyer to help you with this easy, simplified regime that's super accessible to everyone. But if you don't know about this weirdness in the SafeRoads regime, and you ask at the oral hearing, okay, well, am I going to be swearing or affirming my evidence? They will tell you, oh, we don't administer an oath or an affirmation here. It's just your time to tell your side of the story. And yet, one of their adjudicators once drew a distinction between the sworn evidence of the officer and my client's unsworn evidence. Getting chills yet? I'll keep going. I got COVID in April of 2022. It wasn't even a really bad case compared to others who obviously some die, some are put on ventilators. I wasn't even close to that. It was a bad case of the flu. I didn't even cough a lot, but for whatever reason, I lost my singing voice. I could still talk, although I felt my voice was different, but I lost my singing voice. Something in my breath changed radically. And when I say I lost my singing voice, I mean I would sing and nothing would come out. Not just a little wobble or a crack. I mean, nothing. P.S. I got my singing voice back after the Pope's visit, but that's another story. I also noticed I was getting winded when I went up the stairs. I would get out of breath when I would talk to clients. So I spoke to my doctor about it. She sent me for a lung test. I can't recall exactly when. It was months before this incident with the police. And it came back normal. There is nothing wrong with me. And I remember the technician kind of looking at me and kind of smirking. And I wonder how many times he gets people who are stopped for impaired driving related issues going for lung tests. From my professional experience, it happens quite often because clients often come to me mystified as to what happened. The SafeRoads adjudicators rely heavily on what's called the Technical Materials Library. The short form is TML. I think it should stand for Too Many Lies, but they'll never change the title. No one ever listens to me. Actually, I shouldn't say that. You, dear listener, you're listening right now. You and I right now are traveling together on this adventure in law and life. So getting back to, I'll put it nicely, SafeRoads TML. It's a bunch of quasi or pseudo scientific stuff. A lot of mumbo-jumbo, actually. Some of the best pieces of mumbo-jumbo in failure to provide sample cases are an affidavit from Carrie Blake saying pretty much anyone can blow, and another dubious study that says if you can drive a car, you can blow. Isn't that great news, ladies and gentlemen? Aren't you glad to know that if you can drive a car, you automatically can blow into any screening device or any breath testing instrument? Basically, if you're alive, you can blow. I must have been on the verge of death when I was unable to provide samples on those first 4 attempts. I guess I just revived for the last one. You might not notice, but that study really makes me mad. But the adjudicators at SafeRoads accept that study as gospel. I had one client who provided 16 pages of hospital records showing that his lungs had been severely damaged by COVID. He alerted the police to his condition immediately at the outset, and he tried and tried to provide a sample, but just couldn't. And he lost. He lost his appeal. And they say that he can access ignition interlock. No, he can't. He'll never be able to blow and hum into that thing as he's driving. That's not an option for him because he can't blow. But he lost. With 16 pages of hospitalization records. At one point, I lost touch with him, and honestly, I was scared he had died. I worry for that client. I worry for his health. So, me, with a lung test that came back normal, I will have no hope in front of SafeRoads. And what does that mean for me? Well, first of all, you can just picture the headlines. Impaired driving lawyer charged with failure to provide samples. Of course, it's not a real charge. If it were a real charge, I would be able to test the evidence. I would be able to cross-examine the officers. I would be able to bring in more evidence. I'd be able to talk more than just a half hour and provide a brief written argument, which is all we get on the SafeRoads appeal. There are no officers on the SafeRoads appeal. Their evidence goes in as sworn evidence, whatever they wrote. And what's he going to write? He's going to write, she blocked the mouthpiece with her tongue twice. She even admitted doing it. Why on earth didn't I remain silent? She didn't blow hard enough the first time. Then all of a sudden it cut out for no apparent reason. I could see the disclosure already in my mind. And I could see, if I were my own client, the opinion I would give myself would be that you have no hope. How did this system evolve? I'm going to give you a quick background. 2010, BC decides to go administrative. Sometimes it was described as decriminalizing impaired driving. So what did that mean? You might be thinking to yourself, BC can't do that. They're a province. They can't undo parts of the criminal code. No, but they can choose not to enforce it. Yeah, wrap your head around that one. They can just choose not to enforce certain sections of the criminal code. This was a very popular idea that took off running. All of a sudden, we're not enforcing all sorts of parts of the criminal code. You might not know that, but it's true. Where police have an option, they may decide not to charge at all, or they may decide to go with an administrative or regulatory offense instead, because it's less paperwork, it's less time-consuming, and you have fewer arguments when it comes to trying to defend yourself, because you won't be in front of a judge, you won't be in a courtroom, there will be no witnesses, it's just going to be a half hour in front of an adjudicator, online, like Zoom. Yeah, prove yourself innocent, and do it with the least amount of disclosure possible. You'd think you'd get the police officer's notes, reports, any audio or video recordings, right? The director of SafeRoads has to provide just enough disclosure to show the basis for the administrative penalty. So if, as it says right on the ticket that you get, you were charged for whatever, well, you received disclosure demonstrating the basis for the NAP. You're done. No need to give you anything more. Sure, the police have a whole file of stuff against you, but you don't get that. Did you just get another little shiver? It feels like there's a contest of how low can you go? How low can you go with SafeRoads? Like, is just bare bone notes enough? Is one paragraph of a summary of the incident enough? Can we get away with just uploading the tags on the screening device and not the device? We don't want to show you the device, just the tags. How low can you go? You can go really low. So as I was sitting there on the roadside, he had given me the 2 mouthpieces. I thought, it could have almost ended my career. It's not a criminal charge, so would it affect me? I don't know how the Law Society would treat that. I don't know how long it'll be before border guards, employers start just asking different questions. Instead of asking whether you've been convicted of or charged with a criminal code offense, they may just start asking, have you ever been suspended for an impaired driving related offense? And wham! You are treated just like the person who was convicted after a full trial. So what was my problem? I don't mean generally. Lots of people might be chomping at the bit to answer that one. I mean in providing a sample. Women, especially small women, have smaller lung size. Professors Histola and Anderson in the United States did a study on this in 2007. The smaller the lungs, the harder it is to provide a sample. Don't go looking for that study in the TML. It's not in there. The study showed that women with small lung size have issues sometimes providing samples of breath. I definitely did. And the SafeRoads regime, which apparently allows you to appeal the license suspension, would not bring me any relief because I guarantee you, unless the officer made a mistake on the paperwork, I would lose for sure. And I was wholly innocent. This is the regime we have. I am sorry to tell you. So, knowing how unfair this system is, here are my suggestions for what you should do if you're stopped and asked to blow in Alberta or in any other jurisdiction where they have this horrible type of administrative regime. First, record everything. I should have started recording both audio and video with my phone as soon as I saw the check stop. My husband was with me. I should have passed him the phone and had him record. I didn't. Hindsight is 20/20. Do better than I did. But as I was not providing a proper sample and getting more and more panicky as it was going along, I did start to play out certain scenarios in my mind. And here's the second thing that I would suggest you do and what I was planning on doing. Beg for more chances to provide a sample. Preferably, beg for a second screening device. Now, if they say no, and they tell you you don't have any right to a roadside appeal, beg for a voluntary sample at the station. Ask to go and provide a sample on their larger instrument. In Alberta, it's called the Intox CCIR2. Beg to provide a sample there. The sampling criteria are different. You might be able to do it there. But they'll probably say no, because you have no right to that. You can offer to provide a blood sample, but they're going to say no, because they aren't set up for that on a check stop, and they aren't trained to take blood, and there is no provision in the criminal code to allow it, nor is there any provision under the Traffic Safety Act to allow it, so that's going to be a hard no. Making that offer does give a glimpse into your mindset. You clearly aren't afraid. The only reason you'd offer is because you think it will prove that you were under the legal limit, but that's only going to help you if the officer writes down your offer. Because for some adjudicators in the SafeRoads regime, if the officer doesn't write it down, even if you say it happened, it didn't happen. You could ask them to do a standard field sobriety test, SFST. That's where you walk a straight line, you stretch out your finger, touch your nose, do a horizontal gaze nystagmus test. But I probably wouldn't offer that because there are a million ways to fail you on that when you're dead cold sober. And I can guarantee you, because I've tried that And I would have failed those before. My balance isn't fantastic, but it's pretty okay. But the police will tell you to close your eyes, tilt your head back, and do other things that throw off your center of balance. The officer can probably do it because they've practiced it a million times, but they're not going to give you any practice times. You have to do it absolutely 100% perfect the first time. Heel to toe, heel to toe, heel to toe. If you lose your balance at any point and put your arms out or you take a step somewhere, you could be losing it. So that's not really a great option. I don't recommend it. The next one would be beg to be taken to the hospital. And don't leave the hospital until someone takes your blood and has it analyzed for alcohol. Be really insistent because the hospital staff probably won't want to do it, or they will say they're not going to do it. You have to get it because you have to prove your innocence, and your word is no longer good enough. Even if you swore to it under oath that you were trying your very best, they're still going to take your license for 15 months. You have to pay the storage fees, the impound fees for your vehicle, and you will have a $1,200 fine. You will have to pay for ignition interlock for a year, and your insurance is going to go up. Keep your fingers crossed that you don't lose your job over this, because then how are you going to afford all that? Now, there should be very significant consequences for people who are driving impaired. But that shouldn't happen to me. I did nothing wrong. But it very nearly did. The system should be fair. If it were, people would have more respect for it and follow it. As it is now, I have had many clients tell me they have lost all respect for the justice system as a result of their interaction with the SafeRoad regime. I don't blame them. Now, you may be saying, well, it's worth it to get impaired drivers off the road even if we have a rough and tumble, very rough, very tumble, feels more like being beaten up kind of system. It's worth it to get those drivers off the road. If that's what you really think, dear listener, I'm very disappointed in you, I have to say. Just so you know, I've given you the penalties for a first offense, but for second and third offenses, it gets even worse. A second offense, you're looking at a $2,000 fine, plus the victim surcharge, I believe it's $400, and a 39-month suspension. If it's your third offense, you're looking at a $3,000 fine and I forget what the victim surcharge is there, but you won't really care because you're looking at a lifetime suspension. Now, if you were grossly intoxicated and blowing wildly over the legal limit every time, then thank goodness they are going to throw the book at you. I mean, please don't be offended by this, but you're a menace to society, dear listener. But imagine now if all three were for failures to provide samples. I'm thinking of my client with the 16 pages of hospital records. This isn't going to be his first failure to provide, unless he just stops driving. Well, they're going to stop him from driving. Our criminal justice system is predicated on the idea that people intend to break the law. That's mens rea, the mental element. But as we are so often told in this regime, the administrative context is different. You have to prove on a balance of probabilities, which in these hearings feels a lot more like proof beyond any possibility or shadow of a doubt, that you are innocent. Okay, no more scary stories for now. I don't want all of you to go to bed with nightmares tonight, imagining yourself trying to blow, being handcuffed. They actually do that to people, even though this is supposed to be like a traffic ticket. Oh, I'm sorry. I said we were going to stop with the scary stories. It's not really my fault. It is a very scary system. Give me a moment. Let me think. What can I possibly tell you that would make you feel happier? There are a lot of good defense counsel out there doing good work, trying to turn this system around one judicial review at a time. Yes, we can all take comfort from defense counsel. Yeah. If my husband were listening right now, he'd be rolling his eyes. Well, thank you, my dear listener, for traveling along with me today on what appears to be a near misadventure in law and life. They won't always be this grim, I promise. I pinky swear. I even swear under oath, with the hopes that that still means something. Oops, going a little dark again. Sorry. Shannon Gunn Emery signing off for now.